Yo, Dan,
Hello.
what's going on, bro? Can you hear me?
I heard that. Yeah.
Oh, okay. Yeah, no, I'm just going through all this shit right now, bro. I'm at my laptop, just looking at my paperwork again, looking at my affidavits that I can file. What would I got so many affidavits that will protect my license, protect my passport. Should I go in there and stack them all together when I go back in there and just be like, hey, file, put this on my file?
I mean, if they're not making any threats against it, I'd hold off.
They're not making any threats against it now, but I want to be prepared. Like I don't want them to start making. I want them
Then
to
I
back up.
wouldn't.
Uh, okay. All right.
Wanting them to back off. Want to reveal all your cards either.
Right. Yeah. No, I hear. I feel that. I
So
feel that. That's why I was asking. Okay.
as soon as they start, instantly cut them. But let them make the move first, because otherwise it just looks like you're just trying to be
A constitutionalist.
antagonistic with things and just being a nuisance.
Yeah. No, I hear. I feel. I feel. That's a good point. Um. Okay. I got you. I got you, bro. I got you. I got you. I'm ready, man. I'm just ready to get this shit popping, bro. I'm ready to get this shit popping.
Yeah. Oh, I understand that. I
Um.
mean, how part of the battle is just getting into a court, because once they learn what you're wanting to do, they don't like letting you in court.
That's what I'm afraid of. They gotta let me in. It's a public place.
Well, I mean, they don't like letting you get in as far as
Get a
to be able
hearing.
to have a where
So,
you can establish. That's what I mean. They'll let you in the building. They just, they don't like, at least from my experience and others who have been in similar situations trying to.
yeah, you were breaking up. I don't know if we maybe need to get back on the Wi-Fi because I'm back in Wi-Fi now. We might need to call on Wi-Fi.
Hello?
Yeah, we might need to call on Wi-Fi. Are you in Wi-Fi?
No, I'm on my cell phone. It's here. Let me turn the Wi-Fi off and see if that'll help. There, I just turned my Wi-Fi off. See if that'll help. But usually it doesn't interfere with calls.
No, it doesn't. I mean, I was just saying maybe we need to go back on the Wi-Fi because I live in a weird area too, and I
All
don't know.
right.
This isn't a Wi-Fi. I only have one bar with my.
There. Oh,
Yeah, I only have one bar, but I got full Wi-Fi. So I don't know if you want to switch back over to Wi-Fi because you're breaking up a little bit.
because it keeps cutting out.
Yeah, yeah, yeah. I'm gonna hit you back on the Wi-Fi. Peace.
All right.
What's up, bro?
There we go.
Wi-Fi is kicking. I love it.
Well, good. With good Wi-Fi now, we should be able to. I should be able to hear you fairly well the entire time, so that'll help.
Yes, sir. I sent you my filing that I filed. It's very straight, cut to the point. They got to address it. And not only that, I have 2 or 3 more points that I haven't even put in this one. So you are right. Don't blow your whole load in the first thing. I got a couple other things I could do. I could get into the quorum non judice part, which I'm saving.
You're cutting in and out again.
Oh, I said that I'm saving certain points. Like I didn't fill this first special appearance with a whole bunch of shit. You know what I mean? I got a couple bullets left in the chamber for quorum non judice, other things too.
Yeah.
But this first order, they got to address it. They can't dance around any of the shit.
Well, and see, that's the way I do things too. I don't always go in initially and reveal everything. I say enough to give them an idea. Like I use my own stuff for examples. I'm not trying to take over the conversation. I'm just using it
No,
as
I
an
want to hear
example.
it.
But like
No,
with
I
this
totally get it. I totally get it.
prosecutor, with this prosecutor coming up on the 14th, I've already given him I've warned him it's going to be a shit show in court. And then I've given him some of the information as to what I'm going to do and why it's going to be a shit show, but I haven't given him everything to where he can do anything with it.
Right.
I've also gone as far as to give him a few of the court cases that I'll be citing, that he needs to be familiar with, and I straight told him, you're going to need to have a way around these, right? Because of what they are. So, you quit. So, but it's literally not even 1% of what's going to be used and cited in court. But it's enough to let him know that if you go forward with this, it's not going to go like you think. And I've given him enough to know just how screwed he really is, but not enough to where he thinks it's impossible for him to get around it. Because the prosecutor, I've never dealt with that side of the courts. It's the civil side that they're scared of me on. So I've given him enough to make him think, but not enough to let him see just how bad it is. And I'm keeping that intentionally because, well, they're the ones who want to play that game. Fine. You see what I'm saying?
Yeah, no, I hear you.
So I fully understand not using all of it initially. And I'd even tell you, if you don't have to,
don't do it. Right.
Because they're going to respond. If you give them everything up front, like the guy I was talking to that I quit helping because he just didn't listen, he'd tell them everything up front. You know what I'm saying? In his initial filing, everything he put in there, every fucking detail and all of it. And it's like, stop doing that, because then when they respond, they get time to get around all of it. You have nothing to put them on the spot with that they can argue with. You give them time to find excuses, make up excuses,
right.
Come up with something, anything.
Yeah, no,
stop doing that. Put them on the spot. Use some of it, some of the worst of it, in fact, in court on the spot, not in a pleading.
No, you're right. I feel you. Do you think I messed up maybe if I said that, hey, I'm here because I want to, attack these void judgments and, basically fraud? Do you think even saying that was a little too much?
Nope.
All right, cool.
Just don't go into, Go ahead. He's fine out here. I'm out here. He's fine. No, you're good. Sorry, my dogs are outside. You can stay out here, Tyson. And one of them happens to be 150 pounds.
Oh, boy.
And we got him
shitting like a horse
around the time whenever COVID popped up. So I couldn't socialize him like my smaller dog that's about 60 pounds. So he's not aggressive, but he's not friendly either.
Yeah. Yeah, no, I hear you.
So, and it's I got twins, and it's their dog. So they're 16 now, so they're responsible for bringing him out on this with his harness and his leash.
Oh,
I just have to come out here with them just in case there's any issues.
Oh, so you have other kids? I thought you only had one.
One biological.
Oh, I got you, bro. Say no more.
But they're mine too.
I feel you.
So
I feel you.
But yeah.
It's crazy, bro. Like, I'm just ready to attack this. I don't know if I should go back into the court tomorrow or not. I mean, I do have some free time. I would love to go back into the court tomorrow and try to talk to the court clerk, to the clerk of the court, and see why they haven't responded yet. It's been 3 days since I, supplied my paperwork that they said that they were going to get back to me on. I'm going to go there armed with the same more paperwork, 3 or 4 more copies still, and I'm going to try to file it again.
Well, I mean, that's all you can do. Only, like I said, make sure, keep it all to where it's recorded. And if they pull the same stuff this time, like I said, file, I don't know if New Jersey requires, because I know like the state of New York requires a notice of intent to sue before you actually file the lawsuit. So if you need to do anything like that, you need to go ahead and get that done, and then go ahead and file the state lawsuit against them. And it's for denial of services and the violation of your rights, as well as their failure to do their duty. Because, like you said, the law obligates them to do a job.
Right.
So those are the things you sue them for. And then once you file the lawsuit, I mean, you can, while you're writing up the lawsuit, go try to speak to the county manager, right? And inform the county manager of what's going on and give the county manager the opportunity to correct things. Because if you don't do that, the county manager could always step into your lawsuit and say, I can have this problem taken care of, and I'm willing to do so. And if they do, then that can actually get your lawsuit thrown out. You see what I'm saying?
I don't want my lawsuit thrown out, though.
That's why I said go to the county manager before you file it. Inform the county manager of what's going on. Don't mention a lawsuit to the county manager. Don't say that at all. Just inform the county manager that what the clerks are doing, right?
Right.
And then tell them how it's a violation of your rights and everything else. It's denying you services and all that stuff. All right?
Right.
Mention all that. But then you need to point blank ask him if it is something he is going to take care of, and when can you expect to be able to file your documents. And if he says, give me 3 days and you'll be able to go up there and file them, on the fourth day, you go up there and you try to file those documents on video.
Okay.
If they deny you, don't say a word. Just say, okay, thank you, have a nice day, and turn around and leave.
Okay.
Don't say a fucking word about the law. Don't say a word about them violating rights. You've already done that. You've already given them notice. If they deny you again, say, okay, thank you, with a smile on your face, turn around and leave.
Because you have...
And then immediately go file a lawsuit. And include the county manager in it.
Okay, I got you. So I'm going to go to the county manager tomorrow. I never heard of that. But I never heard of a county manager, but I'll look it up tomorrow.
There's generally one going to be in every area. City manager, county manager, whatever it may be, depending on the area. But there generally is going to be one, yes.
Okay, I got you.
Ultimately, that basically when public servants fuck up, you can go to them and they can take it to, the mayor or the county board, and they can actually, through the county board, remove people for these things.
Right, and they don't want that to happen. They're going to want to settle, man, before all that crazy shit starts happening. Because it is going to start happening.
Most likely.
They're going to want to settle or come to some kind of terms. And
Yep. Most likely that's what's going to ultimately end up happening, because you're even going to record the conversation with the county manager.
Yep.
Record all of it, everything. Now, the thing is with the lawsuit, if you do end up filing the lawsuit, because after you go back and they still deny it and you get to file the lawsuit, you include the county manager, but keep in mind, the county manager might still be able to get out of the suit, but he will not be able to get the suit thrown out.
Okay.
Now, he might be able to get out of it if he can show proof that he actually sent instructions over to them and informed them that they had to do it, and they defied that anyway. He's most likely going to be able to get himself taken off your lawsuit. But because they defied his instructions and still violated your rights, he won't be able to intervene and get the lawsuit thrown out.
What if I tell him that, hey, I'm trying to file some stuff over there, and he calls them up and says, hey, or if they tell him, hey, this guy's been here before, and he's trying to file some stuff with child support. What if they make him aware of what is going on?
Then let him.
Okay.
And then if he becomes a willing and complicit actor in this, you don't even have to go back to the courthouse and try to file again. You just straight file the lawsuit. As soon as he says you can't, or as soon as he sides with them, you just say, okay, I'm sorry you feel that way. Have a nice day, defendant, and leave. Because if you file a lawsuit, you're the petitioner, they're the defendants. So that's when you just, like I said, if he sides with them, instantly, you just say, okay, thank you, have a nice day, defendant, and leave.
Okay, would you file that lawsuit in the same county that I'm fighting the child
Yeah,
support?
it's gonna have to be in the same county, unless you file it in the federal courts in your local area's federal courts.
Yeah.
It's either gonna have to go to the federal courts or to your county courts, because the local area is what's gonna have jurisdiction.
The local area first, yeah. Ocean County.
Yeah, because it's county actors in the local courthouse or whatever that's pulling this, or a county courthouse.
Right.
Since they're the one doing it, that's where jurisdiction's going to ultimately be. Because if you try to do it somewhere else, they're going to argue for jurisdiction and venue there, and they're most likely going to get it. Now, the thing is, you're going to lose at the state level. Period.
Lose
if
what?
If you file a lawsuit, that is.
Right, okay. Why would you lose?
Because the state's going to you're asking the criminals to investigate the criminals.
Right.
How is that always going to go?
Right.
But what you do is you go through the county courts, you go through the state appellate courts, and then you go through the state Supreme Court. And then you take it to the federal court. And that's where it most likely will get overturned. If they appeal, the appeal will end up ruling the same way as the federal courts did, which is likely in your favor. And if the federal court rules against you, the appellate court will probably rule in your favor. It just depends on who's paying for the appeal at that point. Whichever side loses. But the federal courts don't protect the state actors the same way the state protects the state actors. So I'm just saying, if you do file a lawsuit, it's not impossible to win at the state level.
Right.
It happens. I'm just saying, expect it to and be prepared for it to not go your way.
No, I hear you. Right.
Your primary goal for the state courts never needs to be about winning or losing. Because again,
right,
you're fighting an uphill battle on that. What you need to do at the state level, the lowest level at the state court, get as much fucking proof, legal codes, case law, and all that as you can on the record. Because when you file your appeal, the record is what they're going to look at.
Right.
So your main concern at a state level lawsuit needs to be getting the record established. Because then you can also turn around and use that same record for your federal lawsuit as an exhibit, as part of your federal lawsuit.
Right.
See what I'm saying?
Yeah, I hear you. But I don't think you'll even get to that point, though. But no, it's good to know.
And it may not get to that point. It just depends on your level of evidence and everything. And in your case, I mean...
Did you see the videos?
No, I got busy.
No, I hear.
At home with stuff.
I think you're going to catch something.
I will be watching them, I promise.
Oh.
But what I do know of your case, I think, and the only reason it is what it is, my ratio here that I'll get to in a second, is because I know how these people work and operate.
Right.
But I think with your case, I'd probably put it at a 60-40, 60 in the state's favor, 40% in your favor of winning. And that's about as high as I'd give anybody.
But when you say state case...
Even my own case in any state, a lawsuit in the state, on the civil side, even my own case, as much proof as I have, at best, could only be given a 50-50 chance.
Yeah, no, I hear you. I mean, the people that are in my network that are... You know what I mean? Like, let me know what they did in their cases. They all say that it's going to be a hard uphill battle. It's not for the weak, and it's not like, oh, just because you file paperwork, it's now they're going to be all scared and running for the hills. You got to keep going. You got to keep going and keep going and keep stacking more and more evidence until they say, hey, we want to settle.
You got to keep getting more violations of law.
You gotta keep stacking shit
law, violation, like as far as all of them goes, it's constitutional violations. Thank you. Constitutional violations or any violations of law. as far as the lawyers or judges go, any violation of their code of conduct or code of ethics or violations of law or constitutional rights, you need to make sure you get documented to bring up again. For the judges, any violation of their judicial canons, you need to call out and get on the record. So you need to take the time, if you haven't already, research their judicial canons for your state. You don't have to worry about the exact local ones, because if the state sets the judicial canons, not local areas. Local ones have to be in compliance with the state.
Right,
you see what I'm saying?
Yeah, I hear.
So,
yeah, I know the supremacy. Yeah.
Learn what the judicial canons are and use those to your advantage. Like, I can guarantee you, one of the first rules in either the first or second canon, is going to be a judge must comply with the law. Must. Now, you understand the law and such and all that jargon a bit better than your average person does, so you understand what the word must means in as far as a legal sense goes, right?
Yeah, it's a lot different than shall. Must is,
Well, no, it's the same. Must and shall are the
Oh,
same.
same
It
thing?
means you
Okay.
don't have a choice.
Oh, I feel. Okay, you're right.
Shall means shall. Can
Gives the option.
or may.
Right, that's the one that gives the.
Those are the ones where you have discretion. If
Right.
it says shall or must, no, that means you shall do that,
Right.
or you must do that.
You're right. My bad. Yep. That's what it was. Yep.
And one of the first canons, like in Missouri, in Washington, it's Canon 1, Rule 1.1. In Missouri, it's Canon 2, Rule 2.1.1. So it's in the second canon in Missouri, but it's the very first one. The first judicial canon, all it says is a judge must uphold the integrity of the judiciary at all times. That's it.
Right. Check your messenger right now. I sent you the documents. I'm telling, like, this one network that I'm in, I'm telling you, if I just go to court to the hearing, to the child support hearing, and tell them to focus on just those facts, they're in a world of a hurt, bro. They're gonna be freaking shivering with just the shit that I have on there, with the proof of service, with the lack of injury in fact. Okay. My bad. It doesn't pop up in the thing? It should.
It does, but send it to me via email.
I got you, bro. I got you.
That way I can put it on, save it on my computer.
I feel you. Let me send it to you right now, buddy. Send it to you right now.
Yep. But, no, I mean, hammer 'em, use everything you can, but like I said, you don't want to reveal
all the cards.
Reveal your hand
right
all at the same time. You don't want to reveal everything early, because again, you give them ways around it all. Like, see, one of the things I told the prosecutor, one of the things he's going to have to get around is Cohen v. California. That's a court case out of the U.S. Supreme Court from 1971, right?
Right.
But in it, it's where the precedent was set by the U.S. Supreme Court that profanity is protected speech, because a guy was walking through a courthouse wearing a shirt that said "fuck the police," and he got arrested for it.
Wow.
And charged for disorderly conduct because his shirt said "fuck the police" walking through a courthouse.
Right.
Well, when it went to the Supreme Court, they said no, he didn't violate a law or anything. You can't have a law because that's protected speech. You don't like it? Don't look.
Interesting.
Literally, essentially what the court said. You don't like it? Don't look.
Right.
You have that option. He can say it if he wants. He has that option. So I told the prosecutor, because the whole issue is I was trespassed because I cussed at him for violating rights at the school. And then the day I went back to the school and actually received the trespass citation, it was after the major of the sheriff's department told me to go up there to show the superintendent the videos. And the major straight told me, "You're not going to get in any trouble. You have nothing to worry about. We'll allow it today." Only for as soon as I get there, his officer issues me a citation under his orders.
A citation.
I didn't bring that up to the prosecutor.
Right.
That's entrapment.
Do you have that part recorded?
Recording.
Yeah, yep.
The major knew the conversation was being audio recorded. And he said it on audio recording. And then had his officer do the exact opposite when I arrived. So I didn't give him that part of it. But I told him about Cohen. He's going to need to be able to get around Cohen v. California. The thing is, he thinks he's going to be able to because there's some case law that he might be able to use, but he's going to ignore one piece of case law, and it's Tinker. And I even warned him that he'd need to be familiar with Tinker, which says that you don't shed your First Amendment rights because you're on school property. As long as your speech is not disruptive, it's protected. Well, if I didn't cuss them out till after the release of the day, I clearly couldn't have been disrupting school classes, could I have been?
You ever filed a special appearance?
Not with the state court. No, I'm not going to. I'm just going to show up the night of the hearing, and the first things out of my mouth is going to be Daniel Gaines here via special appearance under duress.
So they know that it's not under a general appearance.
Correct. And I'm going to have the letter that says I'm being threatened with a warrant for my arrest and the loss of what they deem a privilege, even though the Supreme Court has said it's a protected right.
Driving privileges.
That's the court themselves threatening to violate my rights to force me to show up. That's using coercion to force compliance. That's criminal coercion under the statutory definition. And that's the courts engaging in this now. So that's also something that's going to get brought up.
Bro, the establishment of paternity, in my case, the 45 CFR thing where
it was forced compliance for you.
Yeah, well, they never had jurisdiction from the beginning because I never got read my rights inside the hospital when my daughter was born.
Which is what makes it forced compliance in your case. The only difference is there's no criminal coercion in your case. There's simply extortion in your case.
Extortion and intimidation and duress for me to show up.
There's those elements to it, yes, but that comes with the extortion. Whereas in my case, there isn't extortion, there's just criminal coercion. At least in part.
Right.
Initially, like with my child support, there was no financial documents filed. She was just allowed to put whatever amount she wanted, and that's what the courts went with. I never received any kind of documents from the courts beforehand or anything. You see what I'm saying? Those are the issues with mine. But as far as the new stuff now on the 14th, that is purely, in my instance, criminal coercion, because either show up or we're going to arrest you and take away your other rights. Your freedom of travel, freedom of movement. So that's criminal coercion. Whereas with your entire case, that's just extortion.
You are you familiar with the indoor cultivation equipment from High Tech Indoor Garden Supply or the Scamby company versus Tryon?
Nope.
Yeah, we're using different things here. You're the ones that you're bringing up I've never heard of, and the ones that I have here, it's like totally different. What these got, what my number, yeah.
Because the cases I use, see, the thing about case law is, in order for a piece of case law to be used and applicable to your case, the facts of the case have to be similar. The case has to be similar in nature, or the ruling issued from the court has to cover a broad enough spectrum that it can encompass your case. Those are the only two ways case law applies, which is why a lot of the case law I use comes from the Supreme Court or the federal courts, and it all relates to protected rights, because that's where I'm going after them on for the most part. I'm bringing the other stuff into it, but the entire basis of mine is the constitutional violations, because that's where I feel it can at least force people to look into it more. You see what I'm saying? Yeah, bribery, extortion, racketeering, RICO violations, that might ensnare a few people. In a couple years, everybody forgets about it.
Right.
But you get an entire system caught up in extreme deprivations of rights for multiple decades. People don't forget about that for multiple decades.
Right, but I need you to keep in mind and keep an open mind that some of my research and things that I'm going after in my filings, some of my I don't know what you would call it, some of my case law that I'm using could also be something used for the public that could go viral and really make a big change as well. Because a lot of this
And I'm not
paperwork
saying it
isn't
can't.
right. Right. Because a lot of people's paperwork is fucked up. It's not right. It's not right. If they just look at their paperwork, a lot of people don't know what's on their paperwork.
And see, I'm not saying your case law won't help me and it might, because I still find case law all the time that I didn't know about before, or newer
Exactly.
rulings that expand on ones that I use.
You're right.
I mean,
Exactly.
there's all kinds of different things. So I always look into case law when people give it to me to see if it can be applied in mine or not. And if it can be, I add it to what I plan to use. But one thing you got to keep in mind with my case, I've been at this a long time. Just because I don't recall a single case off the top of my head by name doesn't mean I don't know the case at all. Because reality is, I've got over 7,000 pieces of case law I'm going to be using in these court proceedings. That's a lot of case law.
Yeah, it is, but it doesn't have to go. I mean, that's like 7,000 pages worth of stuff. But the thing is, if you just keep it simple and keep it, you know what I mean? No, but I hear what you're saying, though. We're always learning. We're always trying to see what's up. I was just fascinated that you were going on a different angle, and it sounds plausible, but I have, I mean, the stuff that I'm going after, it applies to your case as well.
But see, the thing is, though, is I'm different from most people because I'm not necessarily trying to change the system. I'm trying to get states expelled from the system or from the benefits program. That way it forces them to throw out those laws and redo them entirely.
Right, but
That's what I want to have happen.
Right, you want the legislation to start whatever, but there's only going to be one way to do that, and if that's
expose enough corruption to force it to happen. Yes.
Yeah, but you're going to have to get the DOJ involved. There's going to have to be a movement.
No, the thing of it is the DOJ won't do anything, and I've already got audio proof of that. Like I said, my case is going to be a shit show. People don't understand the extent of what I have. I've got the FBI and DOJ refusing to do anything about it the instant they hear it's family court related. Before I say family court, they're all about wanting information, details, and everything else. They want to know names and all this. But ultimately, at some point, they're going to ask, what does all this stem from?
Right.
And you say family court. And they will straight tell you, oh, well, there's nothing we can do about that. And that's the end of it.
I was about to ask you, because if they don't accept my filing after I talk with the county manager and all this stuff, I was thinking about going to the FBI and reporting it, but you're saying that the FBI won't help.
Nope. The FBI refused to help me because they took all kinds of information until they found out it was family court, and then they said they couldn't do anything about it. That literally said the family court is a no-fly zone, so we can't mess with any of that or deal with any of that. And it pissed me off. So I forced the FBI to send 4 agents to my house to have a chat with me about this. Don't ask me how I did it, because I don't recommend anybody do it, because there's a very fine line of what you can and can't say that'll make the difference between prison and not prison. Clearly, I didn't go to prison. But anyway, while having those 4 agents here for a 45-minute conversation in February with snow on the ground, while I was sitting on my porch, literally having a conversation with them for 45 minutes, they were forced to admit that, well, they were forced to admit all kinds of things they don't want to admit. And they usually won't admit. And it includes corruption, violations of law, and things of that nature. And it's all on audio recording, and they were aware of it. They just didn't have a choice but to admit it, because they didn't understand the depth and level of my knowledge of law, state, and federal statutes.
Did they have to be aware of the audio recording while they were out there in Missouri?
No. Missouri's a one-party consent state.
Right, so you didn't have to tell them. You didn't have to notify them.
No, I didn't. I don't have to tell them.
Bro,
I just let them know in advance, because then that way
so
they know that they're fucked and there's evidence of it.
So if I take...
Because,
yeah.
The thing of it is, their natural inclination is to lie and falsify and exaggerate things. Like with this issue, the 14th of this month, the court hearing, if this cop or if this prosecutor uses police reports, there's 4 different ones he could try and use. 3 of them are falsified, and there's direct video evidence to prove it. One of them, he manipulates and isn't truly forthcoming or factual with details that he himself put in. He altered details a little bit to make it more beneficial to him, and the video contradicts that even. So all 4 of them I can get thrown out for being falsified, and that's a police officer who did it. That's why I blatantly let them know they're being recorded, because I know what they're going to do anyway. At least this way they know beforehand they're doing it on video or audio recording, so they can't later try and claim differently. They're fucked and locked in.
So I can't take my color of law thing, which I just served a copy of it to my local FBI and have them help me out.
You can try, yes. But be sure you record it.
I got you.
Because again, that's just more stuff you can use in court.
You're right.
Because if you have proof of violations of federal law or violation of constitutionally protected rights, the feds have the authority to do something about it. If they fail to, that's them being aware of corruption, failing to do anything about it, and as a law enforcement entity, they can also be held liable for that.
I mean, they got to help me at least file my shit. I want them to help put pressure for these people to file. So you're saying it's worth a shot, worth a try?
Yeah, I mean, try it, yes. Just record it in case it goes the same way it has for everybody else.
I'm big in the video. I'm big in the video and audio. Like, I'm into, sound engineering, music, beats, DJing. So I got a lot of different little recording devices and video devices and shit.
Because like the guy I was talking about earlier that I quit helping because he doesn't listen, he tried calling the FBI and DOJ. I warned him what was going to happen beforehand. Told him, go ahead if you feel like you might be able to get some help, call them. But be sure you record the call. You can use it in court to your advantage. He called them. It went exactly as I said it was going to go, word exactly to the detail of how I said it was going to go. Only he didn't listen and didn't record it.
That's crazy.
Because they say they don't want it recorded. It doesn't matter what they say. They're a fucking public servant. You have the right to expose corruption. So that means you can record them without their knowledge and consent.
Yeah, especially in Jersey. It's a one-party state.
Well, he's in the state of Washington, and that's a 2-party consent state. However, I've already embarrassed an assistant attorney general for the state of Washington related to that. During the dependency for my daughter, the first day we had court, I didn't post the video or audio recording from the court hearing.
Yeah.
I just made a YouTube video of me talking about what happened, right? That's all it was. Me telling from recollection what happened in the court proceeding. The very next day, all the attorneys, because I was the only one without one, all 3 attorneys were crying to the judge because I posted a court hearing on YouTube. I told the judge the problem with that is it wasn't a recording. It was me talking about what happened during the court proceeding. Nothing more. I said, but as far as it goes, there is a video and audio recording, and I can post those, but that's not what I did post. The judge even straight told them, even if he is recording, I don't think I have the authority to stop him anyway. To which, even in the video of it, you can clearly see my little Zoom box at the top of the screen, because the big picture was the judge, because he was talking. You can clearly see my picture at the top of the screen with me shaking my head and saying in the no direction, like, nope, you can't do shit about it anyway, while I had a smirk on my face. The judge straight told the attorneys, I can't stop him anyway. I don't have the authority to stop him.
Yeah, that's crazy.
And that's a 2-party consent state. I was recording conversations and everything. When they cried to the judge about me recording phone calls, you know what the judge told him?
What?
If you're worried that he's going to record a phone call with you, don't call him anymore. Communicate through email only. You have that option. Don't talk to him on the phone if you're scared of being recorded. Literally what the judge told him.
Crazy.
Oh, but see, here's how bad and corrupt they are, right? This is one of my favorite parts of that whole dependency hearing. Aside from the fact where the judge acknowledged that, yes, I was being forced to agree to it. That's my ultimate favorite part of it, the judge admitting I'm being forced into it. But the next favorite part is the judge told the prosecutor one day, or the assistant attorney general, to type up the final order. Told this assistant attorney general what to include. Told the assistant attorney general, you have until X time to make sure you get it to Mr. Gaines, so that way he has time to review it around a work schedule or any other parental duties he may have, to where he has time to review it, so that way for the hearing tomorrow about it. Well, the guy sent it to me like less than 2 hours before the hearing. Ignored what the judge said. I didn't have a chance to read it fully, so I'm trying to glance over it at the hearing. And I see a couple things in there that the judge never said. They basically made up a couple parts, and one of them was that my anger and aggression was part of the problem. Okay? And that's what prompted the judge to tell him that my anger's at the systems. It's not part of the problem. It's justified and allowable. Right? But there was a few things that they included. The assistant attorney general for the state of Washington did this, right?
Mm-hmm.
It was so bad, I didn't even get to call it out. You know who did?
The judge.
The judge.
Right.
The judge made him change it before the judge officially called the case. The judge jumped his ass right there on Zoom, made him change it right there on the spot, and then jumped his ass some more about doing it.
That's what I'm hearing a lot lately in my network, man. A lot of people are, not a lot, but a few people are getting to the point where they're getting hit with settlement offers. They're getting calls from, third-party people a couple of days after, but also that the judges are kind of helping them out in certain order. Like the judges is trying to trip them up a little bit, but when he can't, he kind of like sides with them and basically just tries to gets the case dismissed for these people. But they try to dismiss it either with prejudice, or they try to dismiss it just to say dismiss. But you want them to make sure that you want to get it dismissed for fraud.
Or dismissed without prejudice, so you can file again.
Oh, no. Well, yeah. Well, in my case, I want my case to be dismissed without prejudice. I want my case to be dismissed for fraud, which is always going to be without the prejudice.
Well, in your case, do you want the order thrown out for fraud?
Yes.
And essentially it would be the case thrown out for fraud, yes.
Yes, because I want to be able to, because what they do a little trick bag where they just say it's dismissed, where you give them the opportunity to say, hey, it was a mistake, and they can redo all the cases again, and in the future. You want to make sure that it's dismissed for fraud, because they'll play it.
That's why I said, go ahead.
Oh, no, you're right. You're right.
That's why I said earlier, with my settlement offer, it will include they must admit guilt. Because otherwise, they're going to include language where they don't have to admit guilt and they get to deny accountability, which means nobody gets in trouble. They get to do it to the next person. They don't have to correct, fix, or change anything. Now, the reason for the sudden shift, all of a sudden last year towards the early to middle part of the year, the reason there was a sudden shift in some of these judges, remember that case I cited to you earlier? Gibson versus Goldston?
Yeah, I remember, yep. About the people
That's
that died.
The reason. Because that was a family court judge. Remember, family court judges always believed they were untouchable.
And they went over and took the guy's property. Yeah.
Well, see, the thing of it is, once this guy took his case federal and the federal court sided with him against the judge, that's whenever there was a little bit of a shift with a lot of the judges in the family law arena, because they realized they are touchable.
And that's the case
where a lot of them, if you push, that's where a lot of them have started to kind of be a little bit more hesitant about screwing you over. because, well, they've been told their protections aren't as strong as they think.
And that's the case where they changed venue and went to the guy's personal home and started taking his property, right?
Yes. Well, it was actually property that the courts had awarded to the ex-wife, but the judge still didn't have the authority to go to his house
And take
because
it.
that was an unlawful search and seizure.
Right.
They didn't have warrants to be on his property, to enter his property, to take his property. He was on his own property recording, and they told him if he did, he would go to jail.
It's crazy. It's crazy.
I mean, there was all kinds of issues, but I believe, based on my reading and understanding of the 11th Amendment,
yeah.
I think the Fourth Circuit Court of Appeals got it right. Judicial immunity doesn't say that the judge is immune in everything they do. The 11th Amendment actually states they have protection from their judicial decisions, is the way of the 11th Amendment makes it seem.
Right, but
so the Fourth Circuit Court saying, no, it's their acts done in judicial nature that are protected from suit. Any deviation from that opens you up to liability.
Right, but
I think that is correct.
Yeah, for sure. But no, it's even easier than that. You could even make it even simpler, especially in family court. Anytime a judge signs a void order, they open themselves up for they lose the immunity immediately.
That's already existing case law. There's already legal codes and existing case law related to that. You could already sue a judge over a void order long before this case.
Right.
Because if a judge issues a void orders lack due process, or they violate rights, or they're done in biased and discriminatory fashions.
Yep.
So they're inherently void by nature, and any judge who engages in any of that is acting not as a judge because they're in violation of every tenet of law that they're supposed to be in compliance with, and it's must comply with, so they cannot claim any type of immunity. The same as if a void order is in place and another judge at a later date uses that void order as the basis for their court order,
right,
they also have no immunity because they lacked any kind of power or authority from the start because it was all based on a void order.
Right.
Void orders are of no legal force and effect.
Exactly.
So anything done based on a void order is absent any power or authority, be it judicial, governmental, state, anything else. It's absent all enforceable power.
And that's why these deputy clerks over there at the court, man, when they're reading through my freaking document, when they're really not supposed to, they're just supposed to see if it's filed, properly and the format is decent enough. That's it. But they were going through and they're like, well, I never heard of any of this stuff that you're mentioning here, and I'm like, you don't need to hear any of it. Just file the shit, stamp the shit, and file the shit, and let's keep it moving.
But see, the thing of it is, though, here's the part of that. In my federal lawsuit, I am also suing a sheriff's department, not the sheriff, but the sheriff's department as a whole, and I'm also suing the courthouse that Judge Yates is employed in. Now, you actually, technically, if he wants to go in, you can take him in. If he's fine, he can stay out. Do you want to go in or do you want to stay outside, Pooch? Excuse me. You can go in, buddy, if you want to. Go ahead, you can go in, buddy. But there's actually case law from the federal level that says you can't sue courthouses, sheriff's departments, and stuff. You can't sue a building, basically, because it's a non-suable entity, quote unquote, right?
Right.
Well, they tried citing that against me. The attorneys did in their motions to dismiss. They didn't know that I actually know things. So I used a Supreme Court case in which the Supreme Court said, no, these agencies can be sued, but it's very limited in how and why. One of the ways, and in this particular case specifically, the Supreme Court allowed the Sheriff's Department to be sued for a failure to train its officers. So I'm suing the Sheriff's Department for failure to train because I even got Internal Affairs making excuses for an officer on video threatening to commit a felony, and then the document that proves that officer committed that felony, and they made excuses for the officer. So there's a clear failure to train, especially when they think they can unlawfully detain people because another public servant wants it done, right? Well, the courthouse, how did they do anything that's a failure to train? Because that's the judge who did that. He's not trained by the courthouse, yada, 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 and you're right. Now, the reason the courthouse becomes a suable entity for their failure to train, there's case law that I cited that says public servants have an obligation under the law to intervene if they witness another public servant violating the law or violating the rights of another citizen.
Right.
So the judge's clerk who was in the courtroom that day when the judge violated my rights, I called him out on it right there on the spot. And then the sheriff's deputy who was in that courtroom, the bailiff, neither one of them called out the judge, and neither one of them filed a judicial complaint against the judge for his conduct and actions that day, even when he violated his judicial canons. Right?
Right.
So that's how the courthouse is open, because it's common practice in all these courthouses. They don't speak up ever when the judges do this. They just act like the judge is allowed because it's a judge. They don't file the complaints or anything else. So clearly there's a massive failure to train as far as what's the appropriate course of action when a judge commits a violation.
Right.
Because they all are obligated under the law to report that judge.
This shit's crazy.
So, the courthouse, you sue the courthouse that these clerks are in as well. Not just the clerks. You sue the clerks, the courthouse, the county manager, but you make sure that the courthouse is for failure to train only. The courthouse didn't violate your rights. The courthouse just failed to train their employees how to uphold and protect your rights and honor their oath. The courthouse failed to educate them and train them on how to honor their oath.
So that's their wiggle room. That's how they're going to wiggle out of my shit, because they're going to say that they didn't train the deputy clerks right.
They can't.
What do you mean?
They can't. If they try to claim that they're not trained, that means they're automatically that means that they're admitting guilt. That means that they're admitting they screwed up because they weren't sufficiently trained in it. So that means, yeah, they did fuck up. It means you win.
Right.
Now, it might reduce the amount they want to try and give you, and the courts might be able to use the law to reduce the amount they give you. Still not going to be like, 90% or anything like that. But they're going to try and do that possibly, or most likely. But
they gave back everything.
They had to have fucked up. They fucked up because they weren't trained, but yeah, they did fuck up.
They waived like $60,000 worth of arrears with one guy, and they paid him back like $40,000 that he paid into it as well. They like settled with him quick.
Yeah.
So
well, see, like I said though, you need to include the courthouse where the clerks are at in your lawsuit, but you need to sue the courthouse only for failure to train.
Okay. I understand.
And then, like I said, I can give you the Supreme Court case that says that they can be sued for that, because the state actors are going to say, oh, it's a non-suable entity, you can't sue it. And then you hit with that Supreme Court case law. So are you going to say this court has more authority than the U.S. Supreme Court? Because the U.S. Supreme Court said, yeah, for failure to train, they can be sued. And the beauty of it is that case, here's how the court cannot ignore that case. That case where the Supreme Court said that a non-suable entity can be sued for a failure to train, the Supreme Court themselves laid out what grounds constitutes the failure to train. They actually laid out, not only, it says included but not limited to is the exact verbiage used in the text of the Supreme Court ruling. So it's not the only things, but they actually lay out several things that this department did that opened them up to the lawsuit. So the Supreme Court literally lays out how you can sue a non-suable entity. What court can assume they have more authority than that court case, than that court ruling? The only court that can overturn that is the U.S. Supreme Court.
Right. So the only way to get after the court, the deputy clerks, is to hit them with the suit if it gets to that point with failure to train.
Well, no, that's only the court. The clerks you sue for violating your rights and everything else, like we discussed earlier.
Oh, but the court, the actual
denial
court.
of service, the violation of your rights, their violation of law and all that. That's what you sue the clerks for.
Right, but the court
the courthouse.
Yeah, the building, the actual building.
You sue for the failure to train those clerks.
Okay, I understand now. Okay, I got
because
you.
Because the courthouse failed to train them in how to honor their oath.
Yes.
So
Okay, I get it.
The only thing the courthouse gets sued for is failure to train. The clerks, they don't get sued for failure to train. They get sued for all the other shit.
All right, so what if I go back to the courthouse tomorrow and the cops tell me, hey, buddy, you got to leave. You're starting to harass her. When I'm being real respectful, I got on video. What do I do then?
That's when you tell the officers trying to get a court document filed is harassment to the clerks and to you officers. Let them say yes. When they do say, are you law enforcement or are you feelings enforcement? When they say law enforcement, that's when you inform them, doesn't the law say and the U.S. Constitution that you swore an oath to say these courts are supposed to be open and accessible, meaning I am allowed under the United States Constitution to go and have the ability to file these documents without interference from the court, the clerks, or you officers? Get them on video responding.
Right.
And then ask them if you can go, if you're free to go. If they say no, don't try to move. Say, okay, I'm willing to leave. However, if I refuse to leave and try to go up there anyway, am I going to be arrested? Let them say yes. And then that's when you smile and say, under threat of arrest, I will leave. Have a nice day, defendants. Because every single person that's a public servant that's within earshot who doesn't intervene is just as guilty as the person who did it.
But I
have the case law for that I can give you.
No, good. Oh, no, I got you. But the thing is, do I get their names before I ask if I can leave or be?
Oh yeah, you need everybody who's around's name and badge number.
Yeah.
And that's when you just tell them. As soon as they say yes, you'll be arrested if you don't leave. That's when you say, okay, thank you, gentlemen. I am going to leave. Under threat of arrest, I will leave. However, I need everybody's names and badge numbers before I go because, well, the defendants have to be named in a lawsuit. And just leave it at that. However, as soon as they come up talking to you, make sure you flash your camera on each and every one of their faces. That way, if they try to get you out of there or say no, they're not going to ID or anything else, you can go to their department, file the complaints against them, in part because of their failure to ID. Because remember, a law enforcement officer cannot enforce the laws against you if he does not identify himself as a police officer. He must identify. Only in an official undercover capacity can they get away and justify not identifying as a police officer.
I think all public officers have to identify themselves because when I asked... Yeah.
There's a few states where it's not a law. However, most policies from law enforcement departments across the nation, most law enforcement departments do have a policy that the officers have to identify, yes.
Because I thought the deputy clerk was going to give me an issue when I asked for her name, but she just gave it up, really easy.
No, those public servants at like a courthouse and business offices like that, like state offices and such, like Department of Health, Department of Sanitation, all those type of people, they have to give you their name.
Right.
All of those have a policy. They have to give you their name upon asking. But only if it's not like you can just walk up to them at random, say, hey, what's your name? And then not have any other communication with them. They don't have to tell you then. If there's any interaction, then they have to identify.
Right.
especially if they're doing anything or speaking or anything in any official capacity, then they are obligated to identify who they are and what their authority or official capacity is. So that way you know, like law enforcement, somebody just comes up behind you in plain clothes, tells you, hey, you got to get out of here. Your natural response is going to be like, whatever, buddy.
Yeah. I served
And then he arrests you for it.
Yeah.
How the fuck was I supposed to, what the hell, what? Whereas if he comes up to you and says, hey, I'm a plainclothes officer, shows you a badge, and says you got to get out of here, then if you don't, provided he's got sufficient legal reason to make you move, then he can arrest you and there ain't shit you can do. But if he doesn't identify himself, you don't have an obligation to listen. Because anybody can go buy a costume, right?
Right.
How do you know they're actually an officer if they're not identifying as one? Because if they identify as an officer and they're lying, that's a felony offense.
Yep. Impersonating, yeah. I'm just trying to be ready. It's good because you're helping me spar for what I'm about to deal with.
I'm a First and Second Amendment auditor, brother.
I feel you. I
I'm
hear you.
literally a First and Second Amendment auditor.
I feel that.
So yeah, I do know this shit. I know it very well. I know how to fucking instigate. I know how to bait them. And it's not that I know how to bait them. It's just I've dealt with these corrupt fucks for so long. I know what they're going to do before they even know what they're going to do. I know what they're going to do before they even know there's a situation to do anything for or with or to.
Yeah, no, I hear you.
I know exactly what's going through their head and exactly what they're trying to do and exactly what they're going to say and do and all of it before they do. And my YouTube videos prove this. There's several YouTube videos where the day before a court hearing, I tell you what should happen based on the law, but then I tell you exactly what they're going to do anyway, despite what the law, Constitution, and case law says. And in every one of them videos, exactly what I said they were going to do, they did to the exact detail.
How did you end up on the Star Report show that one day? Like, how did you end up finding out about that?
Finding out about what?
The Star Report. You were on that one guy's thing. This is where I heard you.
That podcast?
Yeah, it was a podcast with Star.
There was a YouTube cat I used to fuck with. His name was
Florida Boy J.
And
What? Wait, what was his name?
His name was Larnell, but his channel was Fuck Child Support.
Yes. That's the one you were on. Yes.
Yeah, I had been on his podcast and stuff, or on his YouTube show several times, and was always in his comments until he did me dirty. That's why I don't fucks with him no more. He did me dirty as fuck.
How did he do you dirty?
But the cat who had me on his podcast, that was like 2-3 hours long or whatever, he hit me up in the chat on that YouTube channel. I told him to hit me up on Facebook, and that's how we linked up.
Do you remember the guy's name?
JP Brown?
No, it's not him. I heard you on the Fuck Child Support guys thing.
Oh yeah, that his name was Larnell.
What happened there though?
But he did me dirty, so like I said, I don't fuck with him no more.
How could he be able to do you dirty though? I don't get it.
Well, the thing of it is, remember back whenever I did that GoFundMe?
Yeah.
You kicked in a few bucks too?
Yeah.
I didn't want to do that shit because I had tried before and nobody gives a fuck about a father in family court. So I didn't want to do a GoFundMe. The only fucking reason I did is because Larnell told me, and I still have the text to this day to prove it, dude, go ahead and make the GoFundMe, send me the link, I'll put it on my show every day for the next couple weeks, and we'll make sure you get the money you need to go after these motherfuckers.
So it was under his name?
No, it was under my name.
Okay.
The GoFundMe was.
Okay.
But he promised me he would post it on his show to try to get some of his supporters, who was always giving him money, to kick a little bit of money to me to help me out with those legal expenses, right?
Right.
He promised me, and that's the only reason I did that GoFundMe.
Oh.
So then I send him the link, right?
Right.
Send it to him in Messenger. Send it to him through his Facebook page because we was friends on Facebook. This motherfucker removed it off his Facebook page. And then when I asked him about posting it on the Fuck Child Support page or bringing it up, He said, "Oh man, I can't do that. I'm really hurting for money right now. I need to get the money from these people for a minute, and then I'll take care of that."
Really?
And
He
again,
always says,
I have all the messages to prove it.
yeah, don't worry about that. But he always said that he's just a broke guy on the couch or whatever. That was his line or whatever, right?
Yeah, yeah. And I get that. But yet the motherfucker's talking to me about wanting to put together a big-ass barbecue in Chicago, getting a bunch of us guys together that know our shit. He's talking about he'll pay for everything. He's talking about a barbecue for hundreds of people and all this shit. Motherfucker ain't hurting too much for money. Not enough to where he can't let a few people, not enough to where he can't come off of a few thousand of donations to help somebody out after he gave his word.
Yeah, no, the word. I haven't really seen him active. Like he hasn't been coming across my page, my YouTube.
Like I said, I quit fucking with him, so I don't know what happened to him. I called him out for being a snake, and I quit fucking with him. But I call out any of them motherfuckers who are snakes and shady. You say you gonna help somebody, don't fucking get their hopes up to say you gonna help them if you ain't gonna do shit. You don't talk somebody into starting to go fund because you're gonna help push it when you have a bigger platform, and then tell them fuck off, eat a dick, because you're too greedy to let some of your viewers donate to them.
Yeah. No, I hear you. But
The
you don't
only
even.
reason the motherfucker got as big as he did and got as many viewers as he did was because of me anyway. Everybody coming in there wanting me to talk, wanting me to be on there to go over legal shit, because they all would look into it and say, holy fuck, he's right about it all.
Yeah,
I
no,
didn't know shit about the law.
yeah,
I was the one that knew it all.
yeah, you knew more about the law. His angle was just, hey, F them kids and just forget about it. You know, just be cold ice
His name
veins.
was just to attack the baby mamas.
Right. But so what did you need money for? Like for legal expenses? Like you had to pay a lot of money to file for federal?
It was to help with fighting during the dependency with my kid.
Oh, that part. Yeah, that could be expensive. Yeah, that could get expensive for sure when you fight
Right
shit
now,
like that.
I don't have any legal expenses. I mean, I had a $400 filing fee at the federal court, and that's it.
Anytime that you're a respondent in any court, it should be free. So if you could ever get them to file first and you respond, it's always free.
Yes.
So
But
that's
I filed the federal lawsuit, so that's why I had to pay a filing fee.
yeah. But that's why I'm trying to with my case. They were trying to say that my case isn't active. I was like, fuck, it's not. This shit is definitely active. I'm still paying child support. It's definitely active.
If you're paying support, even if it's only a rear